Welcome, learners. Today, we're really taking a deep dive, not just into legal papers, but into one person's intense fight against, well, a pretty imposing system.
Yeah, it's quite the story.
We're going to give you a raw look at insurance disputes, the legal tangles. We've got direct conversations, documents, the real stuff. It really pulls back the curtain on fighting a big institution.
Absolutely. And what's compelling is how it shows that, knowledge of the policy, the legal steps, and just sheer persistence,
Yeah.
these can become incredibly powerful tools.
Mhm.
We'll be pulling out the key bits from these exchanges, giving you a shortcut to understanding the who, what, and why behind insurance claims and, well, litigation when it gets to that point.
Our mission here is to uncover the strategies, the roadblocks, some really surprising ones, and the human side of this case.
Yeah.
One individual pushing for answers for accountability. So let's get into it.
Okay.
Let's start right at the beginning. The spark, denied insurance claims.
Yeah.
The source material lays it out pretty clearly.
Mm.
We hear about specific things Lonnie, the insured person, filed for.
Right. There was that small storage unit claim, something about letter tiles.
Yeah, allegedly stolen, but then it turns out they were a part of some recreation project. And then there's the Finley House theft claim. That's the one he called the big claim.
And right away, you hit the core issue, disagreement over the policy language itself. The insurance company, HomeSite, their argument was that these things weren't an occurrence.
Okay, an occurrence is like the event that triggers the insurance.
Exactly. It usually means an accident. HomeSite argued these weren't accidents under Kansas law. Their lawyer basically framed Lonnie's issues more like breach of contract problems, not traditional insurance events.
But Lonnie pushes back hard on that.
Yeah.
He points to specific wording in his policy, an endorsement, he calls it, for special personal property coverage.
Right, and he believes that endorsement makes it an open peril policy. Meaning basically everything is covered unless the policy specifically says it's not. It's broader coverage. And get this, he even mentions a former adjuster, Tanya Eclude, who apparently noted that very endorsement in relation to the Finley House theft, suggesting she saw it as open peril too.
So wait, if their own adjuster initially saw it that way, how did they justify the no occurrence denial later? It really makes you wonder, doesn't it? How can a regular person ever be sure what their policy means if the company's interpretation seems to shift?
It's a huge point. That word occurrence, it becomes this battleground. For the insurer, it's a shield. For Lonnie, it's like this linguistic maze he has to navigate just to get his claim heard.
And it wasn't just about property theft, right? This occurrence issue came up with other claims, too.
Yeah, claims for slander, libel, and invasion of privacy. Lonnie asserted, hey, my policy covers this personal injury stuff.
But the adjuster, Drew, shot that down, too.
Same reason, no occurrence. Lonnie was like, how is someone slandering me not an occurrence? You can see how critical that definition becomes.
And it gets even more tangled because HomeSite didn't just deny his claims, they actually accused him of causing them harm.
That's right. They claimed Lonnie caused irreparable injury to HomeSite through his persistent behaviors, alleging emotional distress and damaged relations with their customers.
Irreparable injury. Sounds serious. Did they show proof? Lost customers, lost revenue.
Well, that's exactly what Lonnie challenged. Their lawyer admitted they couldn't really quantify it, which Lonnie jumped on. How can you claim irreparable harm if you can't even measure it?
It really shows the different standards of play, doesn't it?
Yeah.
What he has to prove versus what they assert.
Definitely.
Okay, so claims denied, accusations flying. Lonnie starts digging for answers. But getting information turns into its own fight.
Oh, yeah. He describes this round-robin effect, trying to understand his own policy, but customer service sends him to claims, claims sends him back.
And neither could give him straight answers.
Apparently not. They told him he needed an active claim just to get information about the policy he'd already paid for.
That sounds incredibly frustrating, just trying to understand what you bought.
It really does, and it brings up this question about policy terms like, as often as we reasonably require information, what does reasonable actually mean in practice?
Lonnie had an example for that, didn't he?
Yeah, he talked about providing, say, an original receipt for a stolen item, plus a link to his Home Depot Pro account showing the purchase. Proof, right.
It's pretty solid.
But then he asks, is it still reasonable for them to demand unredacted credit card statements if that initial proof is already there and corroborated? It's that constant push-pull over information.
And then there were the missing records. That sounds serious.
Very. 2 specific recordings from the FIU files. That's their financial investigation unit.
A fraud unit.
Right. They couldn't find them. The explanation given was that the investigator, John, did not always mark documents or recordings to be saved.
Seriously, just didn't save him.
Yeah.
But isn't there a requirement to keep those records?
Well, Lonnie points out that Kansas law requires insurance records be kept for at least 5 years. So, yeah, missing recordings become a pretty significant problem when you're trying to piece together what actually happened.
This is where Lonnie starts using legal tools himself, like subpoenas.
Exactly. Subpoenas are legal orders for documents or testimony. And he used them effectively. He uncovered things like his former partner, Greg, rerouting a payment to a personal account.
Ah, and that contradicted what HomeSite had claimed.
Directly. HomeSite had said both of us were paid on that claim. Lonnie's subpoena produced evidence showing otherwise. That's a powerful counter.
But HomeSite didn't like him using subpoenas on businesses, did they?
Not at all. Their lawyer, Chris, objected strongly, called it a fishing expedition, even investigative journalism.
Investigative journalism, wow.
Yeah, claiming it wasn't relevant to the core breach of contract case. But Lonnie saw it differently. He believed they were just trying to keep their internal operating practices under wraps. He felt they didn't want people looking too closely at how they handle claims, especially when they started talking about needing a protection order to stop him publishing employee names online.
So it's not just about the claim, it's about how the whole system operates.
That's what Lonnie seems to be arguing.
Okay, let's move into the formal legal arena. Depositions become a big focus. These are sworn testimonies taken before trial, right?
Correct. Out-of-court testimony under oath. And Lonnie was very strategic about who he wanted to depose, key witnesses like Nina Pelton, who signed that petition against him,
Right.
and John Hirschbein, the investigator whose recordings went missing. Lonnie was very specific about wanting claim histories for people like Jeannie Kettner, another adjuster.
Why claim histories?
To understand their operating practices, as he put it, how many claims do they handle? How many get denied? How many denials get overturned? He's trying to establish a pattern.
And there were logistical challenges too, like witnesses being out of state.
Yeah, John Hirschbein was in Wisconsin, so they discussed remote depositions, and we also get a glimpse into the technical side, objections during depositions.
What kind of objections?
Mostly objections to the form of the question, like it's confusing or leading. The lawyer makes the objection to preserve it for the record, but the witness usually still has to answer. It's different from a substance objection, like relevance, which might actually stop the answer.
Got it. So Lonnie's basically acting as his own lawyer against this big firm.
Mm-hmm.
How does he plan to handle the complex policy language in court?
Well, this is interesting. He planned to bring in an English professor as an expert witness.
An English professor, not an insurance expert.
Right. The idea was to have someone explain how an ordinary person, someone without insurance training, would likely interpret the complex policy terminology. It's a battle over the meaning of words.
Fascinating strategy. Okay, then comes perhaps the most surprising twist in the legal proceedings.
Yeah, this one's pretty unusual. A judge actually recused herself from the case, stepped down, withdrew.
Wow. Does that happen often?
According to HomeSite's lawyer, Chris, almost never. He said he'd never had that happen before in over 30 years. He described the judge basically pushing her chair back and leaving the courtroom.
And Lonnie's take on why?
He attributes it directly to his persistence. He admitted he's very persistent when he disagrees and wants proof.
A judge leaving the bench because of one party's persistence? That really speaks volumes about the intensity of this, doesn't it?
It absolutely does. It's a rare event that underscores just how challenging Lonnie was making things for the established system.
And the challenges for Lonnie didn't stop there. Getting basic court documents was another hurdle.
Yeah, he had to pay out of pocket for copies, 50 cents a page, plus a service fee each time. It adds up when you're fighting a case like this on your own dime.
And then, as if things weren't complicated enough.
A ransomware attack on the state's court filing system.
You're kidding?
Nope. A cyber attack hit the system, forcing the courts temporarily back to old-school paper filing.
And the clerks.
According to Lonnie, many younger clerks had no inkling how to do paper filing because they'd only ever known the electronic system. Just another unexpected, frustrating delay.
Unbelievable.
Yeah.
Okay, this isn't just a legal fight, though. It's deeply personal. Lonnie's conflict with his former partner, Greg, seems woven throughout this whole thing.
Very much so. Greg made a lot of allegations against Lonnie. Burning a sprayer, stealing a vacuum, claiming Lonnie was bipolar or using drugs.
And Lonnie's response?
He denied them vehemently. And often, he says he had evidence to disprove them, like security footage showing Greg himself taking things like a DeWalt shop vac Greg had accused Lonnie of stealing.
And the start of their personal split, the divorce proceedings, was over something specific.
The dogs. Lonnie said he initiated the proceedings mainly to protect his rights regarding their dogs. He called that the whole reason why this thing blew up. It adds this really bitter personal layer.
And Greg had his own legal issues going on, too.
Yes, the sources mention Greg being detained on a warrant related to a CNC machine and brought back from Arkansas. Apparently, HomeSite even contacted the district attorney about it.
How did the DA respond?
According to Lonnie, the DA was not pleased and made a rather pointed comment back to HomeSite about their involvement.
So Lonnie sees Greg's actions, these allegations and emails, as deliberately harmful.
Yes, he describes them as vindictive and feels HomeSite was basically using Greg's personal vendetta against him in the insurance case.
He mentioned Greg emailing the SIU, the fraud unit.
Right. Lonnie believed those emails violated a PFA, a personal protection order, like a restraining order that he had against Greg at the time.
Did HomeSite know about the PFA?
Lonnie says he specifically told HomeSite about it, stating Greg shouldn't be contacted anyone related to the case and that no information about Lonnie should be shared with Greg. But the contact continued.
You can really feel the personal toll this must have taken on Lonnie.
Oh, absolutely. He states he couldn't work for months, since October. He spent his own money on legal help, couldn't get his stolen equipment replaced. All this stemming from claims initially valued around just $4,000.
$4,000 leading to all of this.
He described the amount of work he had to do himself as unbelievable, even hiring someone out of pocket just to help manage it all.
And his interactions with HomeSite's main lawyer, Karen, that didn't sound easy either.
No, he reported she often wouldn't return emails for weeks. At one point, he apparently went to her office and sat in the lobby, but she refused to see him.
It really paints a picture of an individual facing immense hurdles, resource gaps, and what feels like deliberate obstacles.
It raises that fundamental question: how do individuals without deep pockets get a fair shake against huge companies with dedicated legal teams?
What a journey we've taken through this case. It's just incredibly complex, legally and personally.
It really is.
And it drives home that, in these insurance fights, knowing the policy details, keeping meticulous records, and just having that relentless persistence, it can be just as important as the legal arguments themselves.
Absolutely. This deep dive perfectly illustrates that tension, doesn't it? The individual pushing for clarity versus the large institution protecting its position.
Yeah.
It really underscores how, even in industries with lots of rules, these disputes can often feel like a game of controlling information and, frankly, strategic delay. The power isn't always just in the law itself, but in the stamina to keep fighting.
And for you, our listener, I think this really highlights the value of understanding contracts, knowing your rights, and being ready to advocate for yourself, relentlessly if needed. Sometimes the win isn't just getting the claim paid, it's refusing to be ignored or worn down.
And it leaves us with that final thought, circling back to the judge. If a judge actually recuses themselves because of one person's sheer persistence, what does that really tell us about the potential power of that kind of unwavering advocacy? Could that sheer force of will actually change how these systems operate for others?
A powerful question to ponder.
It suggests that maybe, just maybe, the human element that determines individual will can be the most disruptive force in these complex legal landscapes.